Yes, welcome to my live show. I'll give a very important update for asylum seeker and also another important update for those applicant or those people who interested to come to the UK under new permit-based work permit and under new permit system. That is what is regarding shortage occupation list. If you have any question, please feel free to call me at the number appear on the screen. Alternatively, you can write a comment below my live video and I'll give you an answer. Enjoy the show. Yes. First, this is a good news for the applicant, for those who want to come to the UK under new point-based system. The news is, good news is, today 70 new job types being added to the shortage occupation list. So as you know, new point-based system will come from January, and the Home Office added 70 new different types of job in the shortage occupation list. That is basically for working in fishing industry, for bricklayer, working in butcher, work as a butcher, engineer in health sector. And so total 70 new jobs they added in the shortage occupation list. And in shortage occupation list, the candidate only required to salary limit is 20,400. So this is a good news. Also, the bad news, they already deleted some jobs from the shortage occupation list, especially the category of chef, where in Indian restaurants or any restaurants who can hire employee from overseas, and there is a category which is chef in shortage occupation list. Unfortunately, they removed this category and they added 70 different types of job in shortage occupation list. I'll come back to the new point-based immigration system, but before that, I want the new update for asylum seeker. It's not a good news, unfortunately. That is the first. What is the first news is asylum seeker or the Home Secretary ordered the Home Office official to reportedly order officer to explore a plan to building an asylum processing center on a remote island in the South Atlantic, which is more than 4,000 miles from the United Kingdom. So this is very bad news for asylum seeker, because Home Office officials were instructed to look into the feasibility of transferring asylum seeker arriving in the UK to a centre in Ireland, British Overseas Territory, according to the source which came in the news. Unfortunately, it's not a good news, because if the Home Office decided to send all the asylum seeker who is coming in the UK, who is come to save their life in 4,000 mile away, it will be very difficult for them to access to legal services, access to justice, access to their ethnic food, or anything else for the community. They will be disconnected with the whole community. So this is very bad news. Still not certain, but what the Home Secretary Presettled ordered the official to look into this plan. Already there are some charity refugee organization raised this issue and raised their voice, and the Labour Party also expressed their concern about it. So this is the worrying decision for the Home Office. Another bad news is for the asylum seeker is due to the COVID-19, and there is a huge backlog in the Home Office in the substantial interview or the screening interview. Almost 40,000, more than 40,000 people, asylum seekers, are waiting for the interview and the decision. And there's a huge backlogs. And the Home Office has not got enough staff to deal with this 40,000 substantial interview. And accordingly, what they're doing, they are designing a pilot program to address the mounting backlog of asylum claim, to see a private outsourcing firm conduct the interview with often which is vulnerable asylum seeker. This is not a good idea, because we have seen in last couple of times how the private firm deal with asylum applicant in terms of G4 security in detention center. This is very concerning. Now think about if a private firm, already a couple of private firm expressed to take this contract, including G4 Security, Capita, and Sopra Stereo. So if they take the responsibility to interview the applicant, it will be it will be a huge problem for the asylum seeker, because uh, right now the substantial interview is conducted by the directly home office caseworker. But if a private firm decide to conduct the interview, that case the main problem will be the substantial interview will conduct a private firm with the officer or the caseworker, and he will collect the document, he will collect the information, he will record the interview, and then or she will pass the information to a home office official, and then he will make the decision on the basis of their report. So there will be a gap, because if the home office caseworker directly interview the asylum seeker, the asylum seeker can there is a chance then asylum seeker can convince the caseworker face to face, which is more advantage. The caseworker, the asylum seeker can express everything to directly to the caseworker, and the caseworker himself will make a decision. But in private firm substantial interview, the officer who will conduct the interview, he will not make the decision. The decision still will make by the home office official or the caseworker, but the interview record collecting evidence will do by the private firm. So this is bad news for the asylum seeker. Although the home office is struggling, we do understand as well, because now the decision for an asylum application or other application, there huge delay, significant delay, and there are 40,000 people are waiting for only for asylum interview, and they're waiting for decision for asylum application, and the home office saw that they cannot cover all these applications. That's why they're looking for a private firm to appoint to deal with this backlog. So let's see what the home office is going to do. Obviously it will be a huge topics to in parliament as well as in media, but a lot of charity already raised their concern about it. So this was to this week update, that is the Home Secretary Presettled ordered their home official to look into a plan to send all the asylum seekers in a remote island, which is 4,000 miles away from the UK. So what they are planning is basically whoever will come to the UK. Right now, the immigration system is when anyone come to the UK, whether by port or Dover or by lorry, they normally take him in a local authority, or they provide home office, provide the hotel to stay until their decision. But under the new plan, what the home office look into is that when whoever will come seek asylum in the UK, they will take them on a remote island. They will stay there, keep them over there until the home office make a decision. They will be stay on the island. So the difficulty is that person, if they take over in an island, he will not get the access to justice. He will not maybe able to strike a solicitor. So this is the difficulty. He maybe will not get contact with his family, with relatives, with the community. So this is very concerning. A lot of asylum seekers also get help from the community, from the charity, from the lot of solicitor who provide for the services, from ethnic food, mosque, churches. So these types of organization help them, and they get access. Even some people also, when they get an asylum seeker, normally asylum seeker have a permission to work until the decision. So after the screening interview, asylum seeker can apply for work permit. Now if someone stay in a remote island, where he will work, because he got the work permit, he will not able to find a place to work. So if he live in the UK, he will get a place to work because he will get the work permit. So this is the significant difficulty, and hard life is on the way. But we don't know how far they will do it. But in a home office, when they want to make any decision, they don't care about the any impact on the applicant or asylum seeker or any community. So we'll look into it hopefully before December, whether the home office will decide to send back all the asylum seeker in a remote island, or they will keep it in the UK. The second thing is home office decided to give a contract to a private firm who will conduct the screening interview and substantial interview. This will be also bad news for asylum seeker. That's what this week update. If you have any question, viewers, you can feel free to call me at the number on the screen, or you leave a comment and I'll give you an answer. Let me see who asked the question. First question, Shundorlal. Yes, can you help me with EU settlement query? Yes, please, Mr. Lal. Feel free to write a comment in my live video, or you can call me at the number at the screen here on the screen. I'll give your answer in regard to EU settlement inquiry. Next question, Samuel. Please, how long would it take for a decision to be made on a refusal appeal in tribunal? Generally, a tribunal decision or a tribunal decision normally within 21 days decision come. But if you, I don't know whether you ask me that how long it take to get a hearing date. Generally 6 to 8 months we got a first year tribunal hearing date. Unfortunately, due to the coronavirus COVID-19, the process is very slow. There are not enough staff, therefore most of the hearing is delayed. Some of the hearing they are conducted over the telephone. I don't personally prefer telephone hearing, because if the client himself appear to before the judge and he can express his opinion, raise his issue to the judge, there is a possibility that to get justice, because judge himself will see practically the scene, the situation of the appellant, and the appellant can himself explain to the judge. And it is normal, if you speak to someone who's face to face, you will get more sympathy and more kindness. So that's what you will not get in telephone hearing. So anyway, Samuel, your answer is general time frame is 6 to 8 months. Unfortunately, now is significant delay for appeal hearing in first year tribunal. And after the decision, after the hearing, you will get your decision within 2 to 3 weeks. Next question, Shailon Vas. Thank you, Shailon Vas, for your question. Your question is, my friend from India, she is doing her product design in manufacturing her visa. Her visa is expiring in January 2021. What visa you can advise her to? Shailon Buzz, thank you very much for your question. My advice will be you can look into a new point-based work permit system. New point-based system is more easier, flexible, and anyone who can achieve 70 points, you'll get a visa in the UK. You can switch from the UK. Now, if your friend is in tier 2 work permit, general work permit, or ICT visa, or any other category, there is a rule was the cooling off period. That is, if anyone on tier 2 visa, he will not live in the UK continuously 5 years. That what is going to be removed from new point-based immigration system. So now the applicant who is in tier 2, he doesn't need to go back his home country, stay 1 year, and then come back in the UK. Now he can switch to another visa category under the new point-based system, which will come into force from January. So this is a good news for your friend. If she is on visa, he can think about it. Next question. Shailin Vaz, I'll come back on the next question after a short break. Next question. My Shailin Vaz, you asked me a very long question. I'll show the audience. You asked me, my other friend who has settled status, Indian passport holder, do she need to apply for visa? First question, her visa is expiring in December, but she don't want to apply for British passport. She want to remain on Indian passport. Brilliant. So first question, my other friend who has settled status, Indian passport holder, do she need to apply for visa? If she got settled status, she doesn't need to apply for any visa, because settled status, I don't know whether you mean EU settled status or general indefinite leave to remain. If she got settled status, that is indefinite leave to remain, then she doesn't need to apply for any kinds of visa, because she already got ILR for 10 years. She is settled in the UK. Probably her visa will expire after 10 years. After 10 years, she just need to apply for a stamp. So the Home Office will give her a new either BRP card or a visa in her passport. So she doesn't need to apply any kinds of visa. Second question, you asked me, does she need to apply for her visa expiring in December, but she doesn't want to apply for British passport. She want to remain in Indian passport. So she need to apply for Home Office again, just to give her a new BRP card for 10 years, as it is an ILR. So she doesn't need to apply any visa, just Home Office will issue a new BRP card for 10 years. And she want to remain Indian passport, very good, no problem. She can keep her Indian passport, and she can continue to live in UK on ILR. Then you ask me, does she is tier 4 working 20 hours also? Yes, if she is in tier 4 student visa, then she can switch to any other work permit, which will come from January 2021. This is a great opportunity for international student as well. So in terms of your friend, as you said that she is a student, so look at her when she will be graduated, because from the summer, 5th of October, I think from the next week, new immigration rules is coming for international student. So if any international student get a degree or graduated from any university or any colleges in the UK, he or she will get 2 years work permit. So look into it, whether when your friend will be graduated, if she graduated, she automatically will get 2-year work permit. It doesn't matter when she started course, as soon as she will be graduated from next year, she will get 2 years work permit. So maybe she can keep on her own rule. After the 2 years, she can switch into any other work permit under the new immigration point-based system. So that will be, I think, best advice for your friend. I have received a couple of questions as well over the whole week, so I'll give some answer. Mr. Usman Ghani, you asked me, dear sir, my brother is EU citizen. He live in UK. He want to apply for settled status. He don't have passport at this moment. Can he apply with his national ID card? Thank you very much. As yes, he can apply for EU settled or pre-settled status under EU settlement scheme by his national ID card. EU nationals can apply for their settled status or pre-settled status by either by using their ID card or by using their passport. However, non-EU nationals, for example, if anyone from Pakistan, that case he or she will not able to apply for settled status or pre-settled status by using their national ID card, because only European national ID card accepted as an alternative to passport. Because you cannot travel from Bangladesh to United Kingdom by your national ID card. By Bangladeshi, what is NI card? We call national ID card. You must have a travel document, that is your passport. But with the European Union, the UK has an agreement that they can come to the UK by using their national ID card. So as your brother is EU national, so his ID card is a valid ID card, is a travel card for the UK, so he can use and apply for EU settlement scheme under this using by his ID card under the EU settlement scheme. Hopefully you got your question. Next question is Mr. Baby James. You asked me, my friend got leave to remain last year, looking into apply for British citizen. Does she need to go to for B1 test? She has some English level, one certificate for reading and writing. B1 certificate is must or not? Yes, Mr. James, your friend, she need to pass B1 English language test. It is mandatory unless she is under 18 years old or over 65 years old. This is the only exception where someone don't need to pass English test or B1 life in the UK test. Another exception is if someone physically or if someone because of her learning difficulty or any other disease, if someone medically not fit to sit for an exam, then there is a form available in Home Office website. You need to download this form, take it to your GP, and if your GP fill up this form and write and give sign and stamp, then the Home Office will give you exemption from B1 English language test as well as live in the UK test. Otherwise, she must pass B1 in her British citizenship application. But probably, as you said, British nationality. In that case, how your friend get ILR in the UK, because B1 is requirement of ILR as well. So you need to look at into if she already satisfy English language requirement in indefinite leave to remain, such case she doesn't need again in her British nationality application. The rule is once you satisfy English language requirement, if the Home Office accept your certificate B1, then you don't need to satisfy again in any subsequent application. As your friend has already satisfied in ILR, in that case she doesn't need to do it again. But if she didn't satisfy this requirement, because without B1 also some people get ILR, for example, asylum seeker or the family member of an asylum seeker, discretionary leave to remain holder, these people are always get ILR without life in the UK test or without a B1 English language test. So you need to look it into this. Thank you very much for your long question. Next question I'll take from the live, Mr. Ahmed Patel. Ahmed Patel asks me, hi sir, after complete of course, what visa should I apply for? After complete of course, my visa expires in December. Unfortunately, Mr. Patel, I don't get your question. If you are in study, if you are doing any course in any UK university, probably you will get 2 years work permit. So what you have to look at it. If not, then obviously you need to speak to your solicitor. I don't know your current circumstance. According to your circumstance, a solicitor or a lawyer will advise you to you. Thank you very much for your question. So next question, Mr. Gauri, you asked me, I want to know what is the types of FLR partner visa, what form I should use to make the FLR visa application. Thank you very much for your question. There is no form, you can download it. The application you need to make online. If you make an application on 10-year route, FLRFP, there is a form, and if you are on 5-year route, then you need to use FLRFP, FLRM form. So that's it. If you are apply for settlement, then SETM, that was the form is. But anyway, if you go to the Home Office website, there is a questionnaire. If you write how long you are in the UK, what route you are, the system automatically will guide you in the right form. So if you are not make a normal application on the basis of your private and family life, then FLRFP application form you need to use. So go to the Home Office website and fill up this form, and then you submit it online, and then pay the Home Office fee. And before that, you will be required to pay the NHS fee. From the 15th of October, the NHS fee will be £600. So altogether will be around 1500 something for the applicant. Mr. Ahmed Patel, you are a student, sir. Thank you. You are a student. Your visa expired December. You are an unlucky person. Probably you need to do another course. Try, I think, and then you will get work permit for 2 years. I'll be back after a short break again. Thank you. I'll take a question from Facebook Live. Someone make a comment, but before that, I'll give you some important update about European law. Many people are rushing. Some people are not care. Many EU citizen even doesn't know what is Brexit and what is EU settlement scheme. So the Brexit deadline is the same deadline, which is 31st December 2020. Every EU citizen and their family member must make the application before 31st December 2021 or before that grace period, which is June 2021. If you do not make the application in the UK under the EU settlement scheme, you will not able to leave or continue to live. Any European citizen, whoever living in the in the Europe, if they want to come to the UK, they must come to the UK before December 2020 and must exercise treaty rights. That is, they must come to the UK and start work or start as a self-employed person. Or that is what is the requirement is. If you want to continue to live after Brexit, you must be a qualified person under EU law to continue to live after Brexit. You must make an application under the EU settlement scheme, that is pre-settled status. If you are in the UK for more than 5 years or 5 years, if you lived in the UK as a qualified person, you should make an application for settled status under EU settlement scheme. The application process is very simple. You can download an exit ID in your Android or Apple phone, and you can make an application. It will take only 15 to 20 minutes. This is what all about for EU nationals. For EU family members, extended family members, you can invite them to come to the UK even after Brexit. You have time to invite them up to 31st December 2020, but the condition is you must come to the UK before Brexit and exercise treaty rights. Your relationship with your EU family member must be continued at the point of your application, and you must be a person who have a genuine relationship with your EU family members or extended family member. EU family member under regulation 7, those family member who is basically defined by the regulation 7, your wife, your children, and your dependent parents, grandparents, grandchildren, grandparents, great grandchildren. So basically, in the ascendant line and descendant lines, all of them are your family member, but they have to be dependent on you. Dependent means financially dependent. So you must prove that you send money every week, every month, or every 2 months, whatever they need. It's not only you send money. That is you. If you send £5 or £10 every day, every week, it will not satisfy the requirement. Or if you send only £500 every month, it will not satisfy the requirement. The requirement is you must send that amount of money to your family members, to your parents, which they need to survive in their home country. Your money will cover their rent, their medicine, their food, bills, rent, everything. So to live in somewhere in your back home, whatever money they need, you send all this money. If they receive an income by themselves from their pension, from rent, from their own sources, they're not fully dependent on you. So your parents have to be dependent on you. Then you can invite them. Okay, and there is a guidelines for to prove how you can prove they're financially dependent. You must provide evidence of your dependency, your bank statement, your money receipt. If you have any tenancy agreement where they're living, you need to provide them. You need to provide evidence of your relationship, birth certificate, family tree. You need to provide evidence of family photographs. You need to provide evidence that you are a qualified person, that is, you have your your payslip, P60, bank statement, letter from employer. So these are the evidence what you have to provide with the application. And as soon as you can make a correct, appropriate application with enough supporting document, your parents, your family member will get visa to come to live with you in the UK. Same as extended family member. I bet extended family member rule is you need to provide their dependent. I'll come back to you explain how you can invite your extended family member under EU regulation and EU settlement scheme after a short break. You are welcome again. So extended family member basically defined by regulation 8, which means that any relatives who is dependent on you, dependent means financially dependent, you can invite them to come to the UK under EU regulation. The threshold in extended family member is very high. First, you need to prove they're financially dependent on you. You can invite your sister legally under EU regulation and rules, EU settlement scheme. Any EU national can invite their brother, sister, their relative, their uncle, auntie, anyone, as soon as satisfy the requirement under regulation 8. EU regulation 8 define extended family member. Means in plain English, any relatives who is financially dependent on you, you can invite them. Even you can bring them with you if you are living in the same household. For example, if you are traveling from Spain and if any extended family member who is living in same household, you can bring them with you under regulation 7 to directly to come to the UK. If you are already living in the UK, you can invite them to come to the UK as soon as you can prove that they are dependent on you. Dependent means financially dependent. You must provide enough sufficient evidence financially. This is the main requirement. Many application home office reviews just lack of financial evidence. So you need to provide more than enough financial evidence. Every single financial evidence as described in the policy guidelines. I'll tell you what is this. Many people just give them some couple of money receipt, that's it, that is to prove them they're financially dependent. But I don't advise to my client to do this. Only the financial evidence, only the money receipt. There are four types of evidence described in policy guidelines. Caseworker policy guidelines is under immigration rules is basically when an immigration caseworker decide a case, they have some guidelines, they have some tick box that we have payslip, we have bank statement, we have money receipt. So when everything is fine, everything on the file, they give issue visa. When not everything in there, they will not issue the visa. There are 5 types of document, 4 types of document to prove financial dependency, and this is mandatory. Number 1, money receipt, remittance receipt. You must provide the money receipt with your application. That is, if you send money by Western Union or any other exchange company, you must provide money receipt. The second important evidence you should give with the application is your bank statement, because you must do all the transaction from your bank. You send money from your bank to the Western Union or you pay by card, then it will show in your bank statement. So you need to give bank statement with the application. So this is the 2 important document you will give for financial requirement. Your my family member, extended family member, for example, your brother must give his bank statement. When you send money, you shouldn't send money to collect cash from any bank. You should send money in their bank account. Okay, so they will collect money from their bank account. So they need to give their bank statement. when someone collect money from bank in Pakistan, Bangladesh, or India, normally they give a collection receipt. So he should give a collection receipt with the application. This is the 4 important financial evidence. If you can provide these 4 financial evidence, you satisfy the financial requirement. 80 to 90% application for extended family member under EU law refuse just lack of financial evidence. Second, fifth one, if you just show that I send some money, £50 or £100 or £500 to your family member to live, this will not be sufficient. The basic requirement is you should send them that amount of money each month, the money which basically is sufficient for them to live on that country. So if, for example, in India, if you send 15,000 rupee, that should be enough someone to live in India. Okay, in normal standard, you don't need to be lead a luxurious life by money from someone else. So 15,000 rupee enough, or 20,000 rupee enough. So you should send that amount of money which is sufficient for that person to live on that country. If you just send £100, £100, £100, that will be artificial. That is not. Someone needs sometimes 120, sometimes £100. Some month they need to be extra medical care. Some month they need to pay more utility bills. Sometime, for example, in celebration time, Eid time, or in yearly New Year time, they need more money. So this have to be a natural. So as soon as you can satisfy all these requirements, your family member should get, your extended family member should get a visa. So it is important to speak to an experienced EU law expert before making an application, because I deal with a lot of application in appeal. A lot of people make that application by themselves, or speak to some advisor or some other person, friends, family, and accordingly the home office refuse the application. But I think, look at your family member or your brother, your mother will come in the UK for 5 years visa. After they come, they will able to work, they will earn money, they will get benefit, everything. Spend some money for them to go to an expert, take their advice, and make a appropriate application for them. Thank you very much. I'll back to you again after a short break. So I'll take a comment Facebook, like Mr. Lal. Mr. Lal, you asked me, what about pre-settled status, divorce? If someone got pre-settled status and get divorced, does he lose his status? Married more than 5 years. I dealt with same case, couple of case, same types of situation. Probably my client watching this program. The rule is, if you married EU nationals, and if your relationship lasts for 3 years, and if you don't divorce, but you separated from your partner, your relationship with your EU partner break down, in that case you can retain your right of residence under Regulation 10. So as your relationship, okay, if you get divorced, that situation is different. I think you need to speak with a solicitor immediately. Pre-settled status, after 5 years, if you want to apply for settled status, you must prove that you have a genuine and subsisting relationship with your partner. So you need to speak with a solicitor, Mr. Lal. I see, as you get divorced, then you will be in trouble. You will not able to keep your retained right of residence. So as you already divorced, however, if you have any child with your EU partner, in that case, obviously, again, you can keep your retained right of residence. The retained right of residence is very technical. There are a couple of circumstances you can keep. For example, if your relationship break down with an EU nationals, but you live with her for more than 3 years or 3 years, and if your EU partner is still a qualified person and you didn't divorce yet, you can keep retained right of residence. Other situation is, for example, you have if you have a child with EU partner, you have access to your child, you can still keep retain your right of residence under EU Regulation 10. Another situation is where your partner unfortunately passed away, you was a EU family member, you can still keep retain your right of residence. So these are the situation where you don't have relationship, you cannot provide evidence of your EU partner, still you can keep your retained right of residence. There are lots of case law, there are lots of decision come from European Court of Justice, decision come from Court of Appeal, decision come from High Court in that type of situation where someone married a EU nationals and later on their relationship breakdown. So the best things is you should speak to your solicitor, take all your paperwork, explain your circumstance, and someone can advise. If you just ask a question on Facebook, someone will not be able to give you all this information, and it is better for you to make a face-to-face meeting. Thank you very much. Smart Hussain. Brother Hussain, you asked me, I'm expecting naturalization certificate soon, but my partner is EU citizen. Can I apply EU extended family member or for my 13 years old sister from India? What is the option for me to bring her here? She is dependent on me. Brother Hussein, yes, I understand she is dependent on you, but I already explained, if you look at back to my video, I explained what you need to prove 13 years old sister to bring in the UK. You need to provide evidence that your sister is financially dependent on you. But if you become a British citizen, you will not able to exercise European law. But before become a British citizen, you can exercise EU TT rights. So you have to think about it. If you can prove that your sister is financially dependent on you, you are looking after her, you are the guardian, you can bring your sister in the UK. So I already explained that you need to provide financial dependency evidence, then you can think about it. So 30 years old sister, if it is dependent, you are the guardian, the letter come from school, you pay her expense, everything, then there is a chance to bring her, but obviously under the EU law. Under the if you become British citizen, you will not able to exercise EU TT rights because EU law is for EU citizen, not for British national. But if you go to in another EU country, then EU law will be for British national. In United Kingdom, British national cannot exercise EU law. Okay, EU free movement. Okay, so this is the difference is, you know, a British national, if they want to bring their spouse in the UK, they need to earn £18,600. And if a EU nationals want to bring their spouse in the UK, even if they earn the minimum wages, they can bring them here. So you see the difference. Next question, Abdul Kasar. Hello, what about new method that the Home Office will use it interview for 3 parts, Sierra 4G 4S, when we'll work on it? Thank you very much for your question. Just I have update on the beginning of my video about a new update for asylum seeker and for regarding interview. I'll back after a short break. This will be my last update, and I'll take it. I'll finish my live video. So the new update is the Home Office right now 40,000 asylum seeker is waiting for their substantial interview and for their decision. This answer is for Mr. Ibrahim for your question and for others. Home Office is waiting for 40,000 people are waiting for their asylum interview. So Home Office cannot cover all these interviews. So what they're thinking to appoint a third-party private firm to conduct the interview. Right now, a couple of organization is on track, Sierra, G4 Security, then Capita, all these firms are in ready to take a contract to interview all the asylum seeker. What the third party? They are not immigration officer, they are not caseworker. In G4 security, you know the detention center, they control it. And you know how they treat the asylum seeker or detainee. There are a lot of abuse, human rights abuse, people being suicide, people being killed. So there is a bad reputation of private firm to work with the asylum seeker. Now think about, now the all the interview will conduct a G4 security. How he will treat you, how he will take the answer, how he'll collect the document, what sympathy he will show. So this will be a disaster for asylum seeker to give a interview to hand over interview to a third party. So we are concerned. We raise our voice. A lot of charity organizations raise their voice. It has to be stopped. Interview should conducted by the Home Office caseworker right now the way they are dealing. Yes, 40,000 is backlog due to the COVID-19. They should appoint more staff and take the interview as soon as possible. But just because 40,000 people are waiting for asylum interview, that's why they're giving to a private firm, means private individual rather than the Home Office caseworker. They will, a security from G4, air officer from Capita, they will conduct the interview, collect the evidence, and they will give their old record to the immigration caseworker, and he or she will make a decision. This is what they're planning. But think about it. Whatever an asylum seeker will tell the caseworker or the G4 security or any private firm, he or she will not able to record everything. If a caseworker, and the current system is a caseworker will interview you, he will take your details and face to face, and then instantly he or she will make a decision. But a private firm will collect it and make a record and then interview you, and then he will pass it to the another immigration officer who will make the decision. This will be a disaster. Private firms shouldn't be involved in this process. So this is what all about. Another important issue is what the Presettled ordered Home Office official, that is to make a plan, look into it, a system that is to send all the asylum seeker who will come to the UK seek asylum to send in a remote island to process their asylum application, and until the decision, the asylum seeker will stay on that island. This will be a disaster and breach of human rights again. So this is the this week update. It's not a good news for asylum seeker, our brothers and sisters. So we are concerned about it. I hope the Home Secretary and the Home Official and the conservative government will review and rethink, reconsider these two decisions, and to keep safe asylum seeker, to look into the interest and the human rights. These people already escaped from a difficult environment, escaped from a war zone, from their home country, left their property, family, everything to save their life. Now you cannot treat these people like the way you are thinking about it. This Home Secretary, I don't know why she making this too difficult decision in that time, pandemic time, COVID time. People lost their job, businesses lost their job. So this is what the bad news, unfortunately, for this week. Thank you very much, all of you. Have a good night. I'll see you again, hopefully tomorrow. If you have any question, please feel free to call me or send an email or send a review in my Facebook page, send a message. I'll contact you. I'll give your answer on next live.